Магистратура Transnational Legal Practice СПбГУ. Сегодня мы рады приветствовать Андрея Гусева, управляющего партнера фирмы Barenius в Санкт-Петербурге. Андрей прочитает лекцию на тему Legal Neocolonialism and Sovereign Aspects of the National Law. Dear all, welcome to the next part of our series of masterclasses and lectures of leading professionals. And today we have a lecture of Andrei Gusev, who is the managing partner at Barenius, Russia, and he's going to deliver a talk on the topic Legal Neocolonialism and Sovereign Aspects of the National Law. Thank you very much, Andrei, another time for sharing your time, dedicating your time to us, and the floor is yours.
Thank you, Elena. Dear colleagues, as Elena said, I'm Andrei Gusev. I'm the managing partner of Barenius, Russia. Our main areas of expertise are international law, foreign law, advisory in cross-border and foreign projects, management of foreign and multi-jurisdictional disputes. I'm the one who has proposed to call my area of expertise cross-jurisprudence. I'm practicing law longer than 25 years and try to detect major trends. A few years ago, I decided to highlight a certain trend and phenomenon about which I would like to talk today. Public relations began to change drastically roughly at the start of the new millennium. World great powers have been fighting direct open wars in the recent past. In the modern world, however, those wars are replaced by proxy conflicts and by the use of all forms of soft power. For instance, we are now witnessing a global standoff over COVID vaccines. Among the public phenomena which formally ceased to exist in the 20th century are classic colonial empires and colonies. In my opinion, however, they have not vanished completely, but have been replaced by something different. Moreover, a new player has emerged on the field that has never had any colonies in the classic sense. This is the United States of America. First, a few words about the new colonial player. It was the USA which has launched the legal concept of sanctions on the global legal market. As a matter of principle, sanctions appeared as far back as early 19th century, but then they applied selectively. Sanctions started to be used on a large scale, specifically by the United States. From what I see, sanctions have been institutionalized only during the past decade. In other words, influenced by lawyers, sanctions have evolved into a separate branch of law and an area of applied jurisprudence, as well as into a protectionist measure for the national economy and a method of putting political and economic opponents under pressure. From the viewpoint of classical law, sanctions have a rather inappropriate mechanism of application. They are extraterritorial. In other words, they apply beyond the territory of the US to the relationships that have nothing to do with the US. For instance, what are referred to as secondary sanctions are aimed at preventing entities from developed economies from entering into commercial relationships with sanctioned entities or states. By doing so, the US is trying to affect one of the basic sovereign rights of any state and its entities in terms of how, with whom, and on what terms they enter into economic and other relationships. Such states more or less become vassal states of the US, or essentially its colonies, whereas the US itself becomes the mother country of global sanctions or a sanctions colonial empire. Do you recall the example of Iran? In 2015, Iran, the US, and a number of other countries signed a joint comprehensive plan of action under which Iran would roll back its nuclear program, while the US and the EU would lift their sanctions. Yet, in May 2018, the US announced its withdrawal from the program. and not only reintroduced the sanctions it had previously lifted, but subsequently imposed additional ones. As a result, many countries from the European colonies of the US ceased their cooperation with Iranian companies, fearing secondary sanctions from the metropolis. Other examples. In 2018, the Trump administration introduced sanctions against Huawei, a Chinese smartphone and 5G cellular network manufacturer. Later, the Trump administration introduced sanctions against TikTok, a Chinese social platform operation. This and many other events are a clear indication that US sanctions are being used as a tool to counteract political regimes the United States consider unfriendly and hostile. The following examples illustrate how the US used their sanctions as a tool to compete on global weaponry market. In 2017, a new law called Countering America's Adversaries Through Sanctions Act, or CAATSA, was passed. Among other things, CAATSA has introduced so-called secondary sanctions. According to CAATSA, US authorities may impose sanctions on any non-American person in case of a significant financial transaction with a Russian sanctioned person. To do that, no US nexus is required. In 2018, the United States introduced secondary sanctions against a Chinese military equipment agency and its director due to the purchase of a Russian S-40 anti-missile launch system. In 2020, non-SDN sanctions were imposed to a Turkish military-related agency and its official due to the purchase by Turkey of an S-40 from Russia. Also, there have been threats by US officials to impose sanctions on India due to purchases of Russia-originated arms. But what about an energy market? How is the newborn metropolis using sanctions to compete there? In 2020, the United States introduced the first set of sanctions against Nord Stream 2 and Turkish Stream. At the same time, the US administration has been actively promoting US-originated natural gas for sale in Europe. The official excuse for sanctions is the alleged threat from Russia to Europe's energy-related security. It should be noted that Europe's largest recipient of Russian gas, Germany, has been opposing the United States narrative, dismissing American statements on security threats. That said, it is clear that the actual cause of the US sanctions is not protection of Europe's energy security, but is merely a competition elimination tool and subordination of Europe, or I'd rather say European colonies, to the sanctions colonial empire. However, enough about the United States. Let's now talk about another phenomenon which entertains me even more because I'm a lawyer working with cross-border disputes. Another global legal, in the case at hand, metropolis is the United Kingdom. By an ironic coincidence, it is globally dependent in colonial terms on another metropolis, which we just discussed, the United States of America. The UK's unique position on the legal market owes to the fact that international players and participants in economic relationships have a demand for the unification and harmonization of legal procedures, the transparent administration of law, and the effective enforcement of their rights anywhere in the world. I think I forgot to show you the first slide. I'm sorry for that. So please have a look at the US slide. Okay, you see, but yeah, well, let's go on and let's go to the UK and talk about British Empire. Okay, so as I said, international players and participants have a demand for the unification and harmonization of legal procedures, a transparent administration of law, and the effective enforcement of their rights anywhere in the world. This trend is driven by the UK. In my view, the term legal neocolonialism perfectly sums up these processes. I arrived at this conclusion based on the following reasons. Over the past 50 to 70 years, the UK has lost almost all of its overseas territories and colonies. This, however, has not prevented it from preserving its status of an empire. First, the former colonies have reproduced the mother country's law for their national systems of justice. Therefore, states that were former members of the British Empire are using English law or modified versions of English law. Second, in addition to the assimilation of its substantive law, the United Kingdom has a huge share on the international litigation market. Judgments and orders issued by English court are effectively recognized and enforced in member states of the British Commonwealth of Nations and in other developed countries, for example in the US, owing to the similarity in the legal systems or the high authority of English courts. Countries where English courts, where English judgments are recognized and enforced under international treaties should also be added to the list. The whole European Union fell under this category until recently, since the recognition and enforcement of judgments was clearly regulated by the Brussels regulation. Starting from January 2021, the Brussels regulation no longer applies. However, the UK has already made a request to accede to the Lugano Convention, which is almost identical to the Brussels regulation. Hence, we have a situation in which judgments of an English court can rather easily be recognized and enforced in almost all developed countries. This universality perfectly matches the demands of modern international businesses, which look for a convenient and clear route for entering international litigation in order to avoid splitting the proceedings among several jurisdictions. Having regard to the above, the UK can be argued to be an empire of a new type, a legal empire that offers a one-stop shop in terms of the unified administration of law in various jurisdictions. It should be noted that English lawyers are extremely proactive in running after new satellites and followers, thereby introducing and expanding the neo-colony. They immediately rush into new markets and new countries that have embarked on the path of market reforms to teach the English language and English law to naive local lawyers and the local establishment, and to lure them into what they call the fairest court in the world. Speaking of which, any system should develop to survive, and therefore complex systems have a tendency towards self-generation and expansion. Prime example, for example, is a body of officials which normally grows every year. It is my observation that similar processes are underway with respect to the English judicial system, which has started to accept increasingly more cases for consideration, including those which have no substantive ties to the UK. Consequently, English courts go beyond the jurisdiction, which in my opinion constitutes a neglect of the sovereign rights of other states. This trend is extremely pronounced with respect to the Russian Federation, and I will talk about it now. Let us ask ourselves a question: is the Russian Federation a judicial colony of the United Kingdom? The use of national law and referral of cases to national courts is an important sign of authority and the standing of a state. It is important to speak about, it is impossible to speak about a strong state if its transacting parties prefer to use foreign law to structure their business transactions, whereas their disputes are resolved in foreign jurisdictions in the expectation of unbiased and fair litigation, which, for instance, is lacking at home. In 1991, Russia made a transition from a planned economy to a market economy, which required a complete change of the legal framework and judicial system. Such changes could not be implemented swiftly and efficiently, and therefore parties to commercial transactions resorted to things which had operated in a stable way for hundreds of years, i.e. the English law and the English procedure. English law was at the peak of its popularity in Russia until 2014. Most large and mid-sized projects were structured under English law. In the 90s and early 2000s, English law was even used to structure the relationships of partners in public-private partnership projects. There was even a joke since some hydro electro stations were erected on the basis of the concept of public-private partnerships, and the relationships of the parties were regulated by English law, that Russian rivers flow under English law. I remember this being discussed sometime in the middle of 2000s. The reliance on English law reduced drastically after 2014, when a large-scale reform of civil law was carried out and Russian law was enriched with the majority of the legal tools typical of developed legal systems. Nevertheless, Russia and Russian market players still retain a blind faith in the English justice. Many commercial contracts and corporate agreements contain a stipulation that any disputes between the parties to such contracts should be referred to the High Court of Justice of England and Wales. The parties count on the objectivity and fairness of the English judicial system and its practice of scrupulous and thorough examination of the case files. Sometimes the English court becomes relevant when an opponent has substantial assets in countries where English judgments are enforced without any difficulties. Meanwhile, in certain cases, which are becoming increasingly frequent, English courts' acceptance of such cases for consideration means encroachment of the exclusive jurisdiction of Russian courts and, in essence, a threat to Russian sovereignty. This manifests itself in that English courts have a very broad interpretation of their rules on jurisdiction, allowing them to accept lawsuits for consideration that have no clear link to the UK. For instance, all it takes for an English court to establish a jurisdiction over a dispute is the mere fact that the defendants gathered in a lobby of a London hotel and set down on a napkin their plan, which supposedly caused subsequent damage to the claimant. They call it conspiracy. At the same time, the defendants do not need to live in the UK. The said plan can be under Russian law, and the assets in dispute can be located outside the territory of the UK. A stark example of the English justice system's intrusion into Russian sovereignty is the fact that English courts do not shy away from accepting disputes for consideration and issue judgments in respect of Russian companies that have strategic significance for the country's defense and state security. Remember Federal Act 57FZ on strategic sectors of economy. They are 42 sectors, if I remember correctly, including energy, railway, fishery, aviation. I noticed this trend some years ago, and it has only intensified over the years. Below are high-profile cases which illustrate this trend. I work personally a lot on the first case, which is considered by the High Courts of England and Wales. It's Tugushev versus Orlov, Roth, and Petrik. The case started in 2018. In the context of this case, Tugushev is trying to prove his title to a one-third stake in Noribo Group, the largest fishery holding company in Russia. To get the jurisdiction of English court, the claimant specifically involved an English resident named Petrik in the lawsuit, citing that Mr. Orlov had an apartment in London where he lived, by the way, as many as 28 days in 2018, that his children studied in England, that he was accompanied to England by his common-law wife, who had applied for permanent residency. and that a certain meeting had allegedly taken place in London, which gave grounds for filing a lawsuit. In other words, the English justice traps the parties, and there is no escaping from it. One of the reasons for this, in my opinion, is that revenues from all kinds of services, including legal and accounting services, account for as much as 70% of the United Kingdom's gross domestic product. Other examples are Berezovsky versus Abramovich, a famous case. What was it about? It was about oil company Sibneft, strategic sector. Another example is United Company Rusal versus Crispin Investment Limited and Anor. It was regarding Nornickel, another strategic company. Cherny versus Deripaska regarding a membership interest in Rusal, and Bestolov versus Pavarionkin regarding the joint mineral production enterprise in Yakutia. If you have a look at the years of this dispute, you will see that all of them started after the enaction of the Strategic Sectors Act, which came out in 2008. All these disputes have one detail in common, namely that all the cases English judges are determining the destiny of Russian assets that belong to strategic sectors. It is my belief that disputes involving Russian strategic companies should be subject to the exclusive jurisdiction of Russian courts. English court cannot have jurisdiction to determine the destiny of, for example, a blocking shareholder of Gazprom. The contrary essentially means a state's waiver of part of its sovereignty. On top of the unpalatable fact that an English court one way or another issues judgments in respect of Russian strategic companies, litigation in such a court may be an immediate threat to the security of Russian industries. During the proceedings, the parties undergo such a stage as disclosure, during which documents, information, and facts that could be relevant for the judgment to be issued are disclosed. Obviously, no exception exists for strategic companies. Disclosure can apply to such sensitive documents as financial statements, information on commercial value of businesses, and other confidential things. Consequently, the involvement of strategic company in English proceedings means that information regarding the company will be disclosed and could become available to the public at large. Furthermore, some of the strategic sector companies have the regime of state secrecy. I'm not sure that this fact will very much impress English judges. By the way, the disclosure stage can also come in conflict with Russian criminal legislation. In practice, almost all more or less notable corporate conflicts are accompanied by criminal cases, within the scope of which parties are required to sign a submission not to disclose information to which investigatory privilege attaches. The breach of such submission and disclosure of information from the investigation constitutes, by the way, a criminal offense. At the same time, information protected by investigatory privilege can be requested to be disclosed during the proceedings in the UK. In such cases, a party to the proceedings who is required to disclose information is caught, so to speak, between a rock and a hard place. To disclose information protected by investigatory privilege and to commit an offense, or to refuse to disclose and to lose a case under a simplified procedure, and perhaps even commit contempt of court. Generally, English court ignores criminal case instigated in Russia and the restrictions that apply to it. Now, let's try to talk about how to fix the situation. The Russian legislature realizes the unhealthy dependency of Russian business of English law and procedure, and is taking certain steps to reduce it. A reform of civil law has been implemented in the area of substantive law, which has resulted in the most popular tools of English law being introduced into Russian legislation. Such tools are representations and warranties, indemnity, and so on. But what are the conditions for foreign disputes to return to Russia? In terms of procedural law, the situation is less categorical. For disputes to be returned from, as we call it, foggy Albion to Russia, in addition to a prohibition of foreign proceedings in respect of strategic companies, as I stated above, the Russian judicial system must undergo an in-depth and wide-scale improvement. In my view, the main effort should be focused on the following. First, the independence of judges. The problem with independence of judges has two dimensions. First, the judicial branch should be independent from other branches of power. This is a fundamental truism that underpins any decent state. Second, a judge should be independent within the judicial system itself, independent from the presiding judge and from statistical figures, specifically the percentage of judgments to be set aside. A high percentage of judgments to be set aside is a catastrophic thing for a judge, as it creates a threat of missing out on bonuses or even potentially being dismissed from office. This is the reason why Russian judges try to stick to the track laid down for the judicial branch. However, this, as you may imagine, can go against their own personal beliefs. As regards presiding judges, they can determine the financial welfare of a particular judge by influencing, for example, the allocation of bonuses as well as housing and working conditions. Hence, in my opinion, the set of the following measures could be a solution. First of all, the rotation of judges who occupy the position of a presiding judge. Then, reducing the maximum period for occupying this position, and also prohibiting the re-election of a presiding judge, and random allocation of cases among judges, as well as abolishing targets in terms of the maximum number of judgments set aside. A second direction in which Russian procedure should be developed is increasing the prestige of the profession of a judge. In my opinion, the legislature should consider making the examination to become a judge more complicated. Also, a fresh look should be taken at liability for showing disrespect to a court. In the UK, this concept referred to as contempt of court. It is a powerful tool available to a judge that contributes greatly to the parties abiding by the orders of a court. First, an English judge has almost no restrictions with regard to the size of the fine for such an offense as contempt of court. And second, a judge may hand down an order that the party to the proceedings in the most flagrant cases be detained. In Russia, this concept really barely operates. The maximum fine issued by a court does not exceed 5,000 rubles for individuals and 100,000 rubles for legal entities. Another factor that affects quality of the work of the Russian judicial system is the low cost of litigation in Russian courts. Low court fees, low cost of litigation, and miserable policy of disallowing compensation of court costs or allowing only their small fraction. All of these things result in parties preferring to go to court to resolve even most insignificant issues, rather than to resort to methods of alternative dispute resolution, for example. With the number of cases growing, the workload of judges is also increasing. As a result, a court hearing lasts for example, for 15 or 20 minutes, the number of court trials held by a single judge truly skyrockets, and the quality of court judgments leaves much to be desired. In the UK and the US, the cost of initiating and conducting litigation are quite considerable. Therefore, it makes sense to resort to a court only with large commercial disputes. Such a setup of the judicial system allows the burden to be lifted from judges and for the administration of justice to be improved. I believe that the acuteness of the problem will be substantially mitigated if courts at least awarded court costs against the opposing party to the full extent. In that case, a claimant would think hard before filing a small lawsuit. Dear colleagues, my presentation is over now. I will gladly answer your questions.
I have a question. How do you think has a more positive negative impact on the international law? Because colonialism is about inequality, while international law should be equal and universal. And in
Polina, I can't hear you well. I'm sorry.
Oh, sorry. I can repeat it now.
Yes, please.
Do you think colonialism has more positive or negative impact on international law nowadays, and in what spheres it can be positive? For example, anti-terrorist measures.
Well, this is a philosophical question. Let me put it this way. As I said when I was describing the phenomenon, neocolonialism in the field of law provides for uniformity of application of law. It's a one-stop shop. If we're talking about legal neocolonialism, right? We're talking about England, for example. It's convenient, you know. It's very understandable to most of the international players, and you know, we have to admit that we're used to it, and it works more or less well. However, countries like Russia, China, large countries, so-called great powers, they absolutely have to develop their own judicial systems and own legal systems. It's not possible for such countries to let large companies and large disputes go outside and be considered in one universal center of dispute resolution, because the UK is the largest in the world universal dispute resolution center, where perhaps 50% of cases are heard. So let me get one step back. I don't want to confuse you. So in terms of uniformity and understandable application of law and predictability and tradition and thoroughness, yes, it's good. It is good. But in terms of letting developing countries develop and take their own pace, it's bad. It doesn't let them develop. This is my position. Now about security and terrorism. I think we are talking about at the moment private law and security in the field of well, security, terrorism, safety, anti-money laundering, for example, is in the field of public law. Perhaps it is safer in a world which is very globalized and where there is one recognized and accepted policeman. And such policeman at the moment happens to be the US. But as you remember, at the beginning of my presentation, I classified the US as a neo-metropolis because of that. Okay, so in my opinion, we have to learn how to navigate safely in a good way with a high level of safety and security without having necessarily one actor which is telling you what to do. So this is my answer to your question, Polina.
Thank you, and thank you for a comprehensive presentation.
My pleasure.
Thank you, Andrei. May I also ask a question, please? I was very astonished with your examples on the very broad interpretation of jurisdiction rules in the UK, and therefore I see the problem of this legal neocolonialism not only in the less developed judicial systems in China and Russia, but also, and perhaps even rather more, in these broad interpretation of the jurisdiction rules in the UK. And therefore, I wanted to ask if you know about any successive cases of appeal against this broad interpretation within the UK system.
Yeah. Well, Yelena, the problem is that once you are in the hands of English justice, it's almost impossible to escape. It's a tradition, it's a system. Let me try to answer this question in a very long and complex way, since I think we have time, right?
I'm sorry, may I just ask you, не могли бы чуть-чуть камеру пониже сделать, потому что я лично вижу только половину вашего лица.
Камеру пониже?
Да, нет, повыше, видимо, чтобы было видно все, да.
Так? Окей?
Нет, так вижу только половину. Вот, да, вот так,
это не
спасибо.
так камера, значит. Okay. So let me answer your question in a comprehensive way. So it's unbelievable how they managed to create such a huge and complex, truly gigantic system. Think about this. Lawyers, barristers, for example. Well, first of all, in the UK there is a split of profession, as you know. You cannot appear before the court unless you are admitted. Normally, it's barristers. I mean, there is a class of lawyers called solicitor advocates, who have the right to appear before the court. However, in serious cases, they never do this, because I mean, you are supposed to be specialized. You're supposed to do something very, very well. So in a situation with a split profession, it's very difficult to imagine that a solicitor can be a quality orator and quality representative before an English judges. Barristers who are Queen Counsel, so-called silks, who work longer than 20 years and have proven to be very, very high quality. They normally also serve as judges, okay? For example, I speak to a person who is our barrister in one case, and I'm asking him if it's possible for him to represent us on a certain date. He's checking his diary and he's saying that on that date he is a judge in a cartel case. This illustrates how the legal establishment is interdependent of each other, meaning that they understand the shoes of each other instantly, because he is a judge today, tomorrow he is a barrister with an hourly rate of £1,300 an hour, and he's making money. You understand? So this is a machine. you know, split profession, judges, some of them are professional judges, some of them are part-time judges, and so on and so forth. This machine, this huge creature, needs to be fed. It needs to eat. It needs cases, yeah? And once they put their hands on a case, I don't recall a single case where, in my experience, I can check it up for you. Maybe there've been a few, but not in my cases. If there is jurisdiction, that's it. Forget about it. You lost it. You will not be granted a right to appeal. By the way, yeah, in Russia you can appeal in any case. In the UK, you can appeal only if the judge allows you to appeal. You see? And you have to face it, and you have to think how you're going to be litigating. Who will finance your litigation? Because litigation is a multi-million-dollar thing, multi-million-pound thing. Sometimes litigation cases with the involvement of foreign parties go on for 5 years. I can give you an example. Lost jurisdiction. We didn't want to litigate there. I'm sorry, we wanted to litigate in a continental country. We lost jurisdiction. There are stages of litigation. We came to a case management conference, during which the parties and the judge discuss how the litigation will progress. During this case management conference, it was decided that the parties will start disclosure in April, for example. In April. Disclosure is a mandatory part of any English litigation. And then in the course of disclosure, the disclosing parties are not only the parties to the litigation, but also companies around this litigation. Companies which belong to the group of a plaintiff, a defendant, a lot of parties. Let's say 20 parties, they disclose information. And these 20 parties are in 8 different countries. And these 8 different countries have 8 national laws, right? And the English judge is saying, you have to provide information because this is a mandatory part of English litigation. However, out of 8 laws, 4 laws are not comfortable with disclosure. And it's not possible to disclose under the laws of 4 jurisdictions. Right? Then solicitors speak to barristers, and the barrister is speaking up during one of the hearings and says, Your Honor, in this case they say, my lord, not your honor, my lord. Again, this case does not belong here. This is why we have so many issues and difficulties. For example, in Russia, as I said, we have state secrecy. We have criminal cases where there is a special regime of investigatory privilege and so on. It does not belong here. It should not be heard in England. Because you see how many obstacles we have. And the judge still considers the case and finds ways to circumvent these problems. It goes on anyway. The judge says, okay, if we don't consider this case in its entirety, why don't we split it into 2 cases? And have a split trial, I'm sorry. Yeah.
So basically, this is just a very good business.
Yeah, the only way, Yelena, to get out of this, it's a circle, right? Get out of this is to develop own judicial system. Russia, China, India, Brazil, large countries, they must develop their own judicial system. It should be solid. It should be well developed. Judges should be very respected. They should be paid a lot of money.
But there is also an issue of impossibility of the judges in those countries where are the assets, right?
Say it again. What?
I said that also there is an issue of the opportunity to enforce the judgment of Russian, Brazilian, or Indian courts in other countries where the assets might be found.
To involve
Isn't
the judges.
That also? Mm-hmm.
To involve the judges.
No, I mean that the decisions of Brazilian courts, of Russian courts, should be enforceable in other countries. So this is not a problem with the UK courts, as you mentioned.
Yes, of course. Yes, I agree with that. But imagine a situation where an owner of a large conglomerate is litigating in London. Have you seen a person whose net worth is beyond $100 million, for example, who does not have residence in one of the countries outside Russia or China, for example, who does not have bank accounts there, who does not have businesses there, real estate there? That's the problem. Because if a litigant is Russian, lives in Russia, works in Russia, have all his money in rubles, and travels only to Crimea and Sochi, there is no threat, except for one, if he doesn't, fulfill the directions of the English court, he will not be able to travel freely in the future. However, it will be livable. But all our large owners of businesses, all of them, without any exception, they are global. That's the problem.
I see.
Yeah.
Thank you very much, Andrei. Do you have any other questions? I think that they're very impressed. They need to digest this information.
Yeah. I would like to say that it's very maybe strange that I'm saying these things, because most of the money I'm making are made because of litigation in common law countries, and first of all in the UK. But I cannot bypass this simply. You see, the difference between the UK and US is that US is like a planet in terms of the size of its economy and the issues it is occupied with on a daily basis. They don't need anybody. US lawyers don't need foreign lawyers. They can survive without them. This is why, US are not trying to vacuum clean disputes into the US. UK has a different concept. It's a global center for legal, accounting, and financial services. They need foreigners to come to them.
I see. Thank you very much. And thank you in particular for pointing out the problems and for also proposing certain ways for overcoming these problems. And once again, I thank you from the part of the students of the Master Program Transnational Legal Practice, and hope that you are going to speak to us another time in live here in this wonderful hall of the Academic Council of the Law Faculty. Спасибо огромное, Андрей. Для нас огромная радость была сегодня слушать вашу лекцию. Спасибо. Коллеги, поблагодарим нашего спикера. Спасибо большое. До скорых встреч.
Thank you. Have a nice day.
Bye-bye.
До свидания.